In this session, we're going to cover the first topic of torts. That topic is intentional torts. Before we begin discussing intentional torts, I'd just like to say that, like some of the other material we've covered, torts is a class that you cover your first year of law school. Torts would be your first semester and your second semester. So in this chapter, about 40 pages, the textbook has condensed down an entire year worth of law school for us to examine. So you may have heard someone use the term tort. What does it refer to? What does that mean? A tort is simply refers to a wrongful act in which an injury or a harm is caused to a person or to the person's property. In a tort case, the person is seeking compensation for the injury to either themselves or their property. So harm happens to the person. If someone is injured, they would be seeking monetary damages to make themselves whole as a result of the injuries they sustained because of the wrongful act. So you think of a tort and maybe you hear personal injury and civil wrong, and so you wonder what's the difference between a tort and criminal law. Well, the major distinction is that with a tort, it's not an act that is outlawed by society. Criminal law is a set of conduct that society has decided is improper and cannot be permitted in a civilized society. So, stealing, robbery, fighting someone with serious injuries, killing someone, various conduct that's not permitted. But in tort, you're talking about some conduct that's happened that's caused injury, but it's not conduct that has been criminalized by society. So there are three types of torts that we'll talk about. First is intentional torts, and that's the tort that we're going to cover in this session. Then in a later session, we're going to talk about negligence and gross negligence. And negligence is really what makes up the bulk of tort. As far as the lawsuits that got filed, the tort lawsuits that get filed, they are primarily a negligence-based lawsuit. The intentional torts that we talk about are torts that are out there and happen, but negligence is probably 85 to 90% of the tort cases that happen, in whether it's business or just in context between two individuals. Negligence is by far the largest category of tort lawsuits. So let's briefly distinguish intentional torts from negligence. And we'll talk about negligence in much more depth in another session. But it's important just to briefly understand the difference between an intentional tort and negligent conduct. So the main distinction between these two types of what conduct you deem to be an intentional tort and what conduct you deem to be negligence. The determining factor in distinguishing between the two is the intent of the wrongdoer. So intentional torts have an element of intent or purpose to commit the act. That means the defendant was acting deliberately. In an intentional tort setting, there is an intentional act. The act that's being done is deliberate. By contrast, in a negligence action, you lack that specific intent, that deliberate action. Usually is the result of a failure to follow or use proper care. So in the common classic sense, negligence oftentimes is an accident. If you think about a car wreck, are car wrecks intentional? Often no. Most car wrecks result because of an accident. There may be some negligent conduct, such as following too closely or speeding or not looking properly, and that's the result of a failure to use proper care. So if you're driving down the road and you're not paying good attention and you don't realize that the stoplight has turned red and you continue moving forward and you strike another car, that is not an intentional tort. Rather, that is negligence because it was your failure to use proper care to observe that the stoplight was turning red. By contrast, an intentional tort is one in which you mean to perform that act. So if it was someone coming through the intersection that you had a grudge with and you hated and you wanted to wreck their car and you purposely went through the light because you wanted to hit them and then you hit them, that would be an instance of an intentional tort. So let's look a little closer at intentional torts. For an intentional tort to exist, the plaintiff has to prove these four requirements. You have to have intent. Intent, as we'll talk about in just a second, can either be implied or you can have actual intent. The plaintiff also has to prove that it was a voluntary act by the defendant. You also have to show causation. And lastly, you have to show an injury. So the causation element is what connects the implied or actual intent with the voluntary act with the injury. So the intent to carry out this voluntary act has to be the reason that the injury occurred. Without that connection, that causal link, then you don't have a recoverable intentional tort. So if someone, let's take an example of Andy does not like Samantha. So Andy intends to throw a baseball at Samantha. He throws the baseball at Samantha and hits Samantha, and Samantha falls down. Well, as Samantha is getting up, Samantha then trips and falls back down and lands on her arm and breaks her arm. Well, there was an actual intent there to harm Samantha because he intended to throw the ball at her. That was a voluntary act. He decided to do it, and then there's an injury, the broken arm. But is there a causal link between the voluntary act of throwing the ball at Samantha and the injury? The answer is no, because that act didn't cause the injury. The injury was caused because Samantha stumbled and fell. So in that scenario, you would not have an intentional tort. By contrast, if the ball had knocked her over, and when she fell over and landed, if she had broken her arm at that point, it would have been an intentional tort because the cause for the broken arm was her falling over from being struck by the ball. So let's talk a little bit about intent. Intent is where you're acting with a purpose, or you have knowledge that the act can cause an injury or harm to another person. So this is looking at what did you mean or intend to do? What was your intent for what you did? So the defendant, the person doing the harm, does not have to know that the injuries would occur. Rather, the defendant only has to know that the act may have consequences. So in our scenario of them throwing, forget the guy's name, maybe I said Andy, but the boy throwing the ball at the girl, Samantha, he did not have to know that the ball would knock her over and cause her to break her arm. Rather, all he has to know is that throwing the ball and hitting her may have consequences. And so in that scenario, knowing that he could throw the ball and hit her and possibly have consequences, that's enough to establish an intent. So a moment ago, we talked about intent can either be actual or implied. So actual intent is where the defendant intended for the specific consequence to occur to the plaintiff. And we're going to look at a few examples of actual intent and implied intent on the next slide. Implied intent is where the defendant knew that the consequences of the act were certain or substantially certain to occur, although the defendant may not have intended any consequences. And the Last point to make is that intent can be transferred. That means that the intent may be meant to carry out the act, but it was directed at one person. But if you actually cause harm to another, that intent is transferred to where you can't say, well, I didn't intend to hit Samantha. I intended to hit somebody else that's there or some object. If you, it's not a defense to say, well, I wasn't trying to hit them, I was trying to hit somebody else. That's not going to be a defense. Rather, the intent is going to be transferred to the unintended person. So let's look at some examples here. So actual intent. John is mad at Adam for eating his ice cream sandwich. Who wouldn't be mad? So John decides that he's going to punch Adam in the face. And John does that. John had the actual intent here to harm Adam, and he had the actual intent of punching Adam in the face, and he did it. So that's an example of actual intent. Implied intent, just the classic example is given in the textbook, and that's where Winston is working at, or Wilton is actually who it is working in his office building, and he goes to the window and throws some trash out. And it falls from the window and it hits Olivia, who's walking by on the sidewalk, and it causes an injury. Well, there, Winston didn't have a specific actual intent to throw the trash and harm Olivia, but he was certain or should have substantially known that throwing something out of a window could hit someone and cause harm. And so that would be the classic example of implied intent. Transferred intent. Let's go back to the example with John and Adam. John's still mad at Adam for eating his ice cream sandwich. As such, John throws the punch at Adam, but Adam ducks and John punches Tina, who is beside Adam. And so in that example, the intent, John had no intent of punching Tina. He intended to punch Adam. But that intent would be transferred from Adam to Tina, such that Tina would be able to establish intent for the purposes of an intentional tort against John. So on intentional torts, there is a defense when there's consent. So that makes sense. If someone consents to the act and then they have harm from the act, it doesn't seem fair for them to then be able to sue the person that inflicted the harm. Everybody was in agreement. So if the plaintiff agrees to the act that the defendant does, there's going to be no recovery for an intentional tort. The example here that I give is John and Ted agreed to wrestle one another on the trampoline. During the wrestling, Ted is injured. There's an agreement there for them to wrestle. Ted would not have an intentional tort against John because of his consent. It's important to note as well that consent can be implied. The classic example is sporting events. When you're playing football, it's implied that there's going to be contact and that someone may be injured. It happens all the time where somebody tears an ACL or hurts an arm or breaks a bone because they're being tackled in football. You don't see football players suing other football players because of an intentional tort of them being struck when they were running with the football. Instead, consent is implied in that scenario and would act as a defense to any possible intentional tort claim. So there are a number of intentional torts, and we're going to look at these briefly. But these include battery, assault, false imprisonment, intentional infliction of emotional distress, defamation, trespass, nuisance, conversion, and fraudulent misrepresentation, as well as a few others that we'll cover. Let's begin with battery. Battery is the non-consensual and intentional harmful or offensive touching of the plaintiff's body. So this is where there's an actual contact. So let's take our example that we talked about with the actual intent a moment ago, where John throws the punch at Adam. That is going to be one, intentional, two, it's not something that's consensual, and it's a harmful or offensive touching of the plaintiff's body. So in that scenario, John has committed the intentional tort of battery. So the contact that occurs may be by an extension of the defendant. So in that example, let's go back to the case where the boy threw the ball at Samantha. In that example, the contact occurred by the ball, which is considered to be an extension of the defendant because the defendant's the one who set it in motion and threw it at Samantha. So it's not a defense to say there wasn't a battery here because all I did is I threw a ball at Samantha. That would still qualify as a battery because it's an intentional and non-consensual harmful or offensive touching to Samantha's body. It's even possible for a battery to occur when there's no injury. The example that the book gives, which is a good one, is when you spit in someone's face. That's an intentional, usually most of the time. I guess you could accidentally let a little bit of spit out, but if you're in the scenario I'm thinking of, is you just straight up spit in somebody's face. In that example, it's not consensual. It's an intentional touching of the plaintiff, and it is obviously offensive to the person, although it may not cause injury. That would be enough to qualify as a battery. And like we talked about, the contact may occur by putting something in motion, and that's the example of throwing the ball or throwing a stick that hits the plaintiff. Next, assault is, you usually think of assault and battery together, but there is a big distinction between them. Assault, the distinguishing factor is that with an assault, there's no requirement of there being a touching. So for me, I hear assault and I always think of they've like physically assaulted the person. But in the context of an intentional tort, an assault does not require a touching. If there is a touching, then it would be appropriately characterized as a battery, not an assault. But oftentimes an assault accompanies a battery, and that's because assault is an intentional act that creates a reasonable apprehension of imminent harm. And so it's very often that you have an assault that then turns into a battery. So take the example of John and Adam. John's mad that Adam ate his ice cream sandwich. John may cock back his fist and create a reasonable apprehension in Adam of an imminent harm. He may have a reasonable fear of imminent harm because John has pulled back his hand like he's going to punch him. That is an assault. And then if he carries the punch forward and actually makes contact with Adam, then that turns into a battery. So in that example, you've got both an assault and a battery. So the assault is the attempt or the threat of harm, but there's no actual harm that occurs. When the actual harm does occur, then that's a battery. So the example that I give is that someone threatens to hit you with a bat, but they don't actually hit you. If somebody, if you say you're outside and somebody pulls a bat out and brings it up like they're about to swing it at you, that's going to create a reasonable apprehension or reasonable fear of imminent harm. And so that would be an assault. Now, it's important to note that assault requires the threat of causing the harm accompanied by the present ability to complete that act, to immediately complete that act. So you can't, if you threaten somebody but you don't have the means to carry out the threat, it's not going to be an assault because if you threaten somebody but you can't pull it off, then that's not going to be an assault. So the example I give is let's take the bat. If the person says, I'm going to hit you with a bat, but they don't have a bat, then there's no ability in the present, there's no facts in which the person should have a reasonable fear of imminent harm. If they're going to hit you with a bat, but there's no bat, then it's not a reasonable basis to fear imminent harm. Another example would be is if someone tells you next week, I'm going to do this to you, do an act. If they threaten to hurt you next week, that's not assault because it's not an imminent threat of harm. Now, the next week may come and they may be there to threaten you, and they may have the means with which to do it, and then you would have an assault the next week. But telling someone on Thursday that they're going to assault them the following Monday would not be enough to qualify as the intentional tort of assault. False imprisonment. False imprisonment is what you would expect based on the name. It's where you hold someone against their will without the legal authority to withhold them, to detain them. So someone comes to your home and they're there and they want to leave, and you tell them you can't leave, and you lock the doors and block them from leaving. That's going to be a claim for false imprisonment because it's a confinement that happens. You're restraining somebody against their will. It's a confinement that happens by either physical barriers, physical force, or threats of force. So you don't have to physically lock the door, but if you tell them if you leave and go out the door, I'm going to shoot you, or I'm going to hit you with a baseball bat as you're going to leave, then, and they're feel constrained and can't leave, in those scenarios, you're going to commit the intentional tort of false imprisonment. So it's important to note that the plaintiff actually has to know that he or she is confined. So if you're walking around at a department store, and say you go in Macy's, and Macy's locks the doors and won't let anyone leave. Well, if you're walking around shopping and then by the time you leave, they've opened the doors again, were you really falsely imprisoned? No, because you're not being held against your will. You had no idea that the doors were locked. So it's important or critical that the plaintiff actually know that they're being confined, because false imprisonment requires that the person be held against his or her will. And if you lack any knowledge of the confinement, how can you be held against your will? So for store owners, this often comes up for them, and I've defended a few cases where stores have been charged, or at least have been sued for false imprisonment because they have detained somebody who they believed was stealing or shoplifting. Well, in that instance, store owners are usually shielded from false imprisonment claims so long as they have acted in good faith, meaning that they had a good basis, uh, good facts to believe that the person being detained had actually shoplifted. And then when they do detain them, they've got to do it on a reasonable basis. So it's got to be reasonable in terms of the manner in which they approach them and detain them. It can't be, you can't be tackling them and handcuffing them and stuff. It needs to be in a reasonable manner of putting them in a room, only holding them for a short period of time until the police get there, things like that. But as long as the store owner acts in good faith and manner in which they detain the person suspected of shoplifting is reasonable, then the store owner is not going to be liable for false imprisonment. So the intentional tort of intentional infliction of emotional distress. This is a claim that you see alleged a whole lot in tort lawsuits, but it is a claim that really is a little hard to prove. And for that reason, oftentimes these claims don't make it too far. So they're often added to a lawsuit, but they're usually not successful in a lawsuit, at least in Tennessee, and that's my experience of what I observe. But this intentional infliction of emotional stress is where it's the act of causing mental anguish to another person through outrageous conduct. Tennessee recognizes this tort. They also recognize a negligent infliction of emotional distress, which, like we talked about a few minutes ago, the difference there is the intent. Here, it's a deliberate act, and a negligent infliction of emotional distress, you lack the intent. It's more of a failure to follow the proper standard of care. So to recover based on an intentional infliction of emotional distress, the plaintiff must show these four things. They must show that the defendant acted intentionally or recklessly. The defendant's conduct was outrageous. In Tennessee, outrageous is defined as conduct that a civilized society would not tolerate. Third, the plaintiff must suffer some severe emotional distress. And lastly, the defendant's acts must again be the cause of that emotional distress. So you've got to have that causal connection there. So the mental distress must be foreseeable from the defendant's actions. And most jurisdictions, including Tennessee, will require that a physical manifestation of the mental injury. So maybe where you're not sleeping well, you're not feeling good, you're having anxiety, maybe your blood pressure's up. Things like that would be a physical manifestation of the mental injury. So outrageous conduct, it's like I said, in Tennessee is defined as conduct that would not be tolerated by a civilized society. That's going to be more than just insulting, abusive, threatening, profanity, or annoying conduct. So it's really got to be something extreme and outrageous, as opposed to just being a jerk or being difficult to deal with, or being loud, using profanity. Things like that are not going to rise to the level of outrageous conduct. And like I was saying before, these cases are hard to prove, and this is one of the reasons, is that the outrageous conduct just doesn't mean the person's a jerk or they're difficult to get along with. They've really got to do something that is inappropriate. And the closest and the best example to use is like, sexual harassment in the workplace. Like that could be enough of an outrageous conduct that it would be something that society would be deemed to not tolerate, especially as the Me Too movement has been going on for the last few years. Society's viewpoints on what's acceptable and what's not is kind of tightening, and so it may make it easier to prove a intentional infliction of emotional distress claim in the context of a sexual harassment claim. So you've got the difficulty is proving the outrageous conduct, and the second difficulty is establishing that you do have a severe mental injury, emotional distress. It's got to be something more than I was upset over something and I, was worried about it for a few months and stuff. Usually, you've got some physical manifestations, and it often requires that you've seen a medical person. But medical evidence is not a requirement in Tennessee. You don't have to establish medical evidence in order to recover. Defamation. Defamation is the publication of an untrue statement, whether it is through oral or written publication. But it's an untrue statement that injures a third person's reputation. And defamation When we're talking about that, we're talking about factual statements, not opinions. Opinions about people um, are not, it's hard to prove that's true or untrue because it's an opinion. But a fact is something that is either true or not true. So the person either committed the conduct or they didn't. But an opinion about someone, and you'll take like public officials, the president, there's always opinions about him. Well, opinions about him, about how he's doing in the office, or how a policy is, or how a new law that he's pushing is opinion. What would be um, the possibility for defamation is when you're talking about factual statements that are untrue. So a factual statement claiming that the president embezzled money, um, that would be something that's a factual statement. That's not an opinion. And so that claim, if proved to be untrue and you meet the uh, intent requirement that we'll talk about in a minute for public officials, a little different than a private person, but that would be an example of a factual statement as opposed to opinion. The only exception for opinions is if it's an opinion that implies a statement of objective fact. So you've probably heard the terms libel and slander, and that's just the breakdowns for the type of defamation that you're talking about. So libel is written defamation. If you sue a newspaper or a magazine, that's going to be for libel because that's written publication. And so that would be where a newspaper has printed a statement about you that is untrue and it causes injury to your reputation. Written defamation, libel, the injury is presumed. You don't have to go out and show that, hey, I was injured by what the paper wrote that was untrue about me. Rather, your injury is presumed, and you just have to prove that the statement published was untrue. Slander, on the other hand, is oral defamation, and so this is what's spoken. And so, in those instances, except for the small exception of slander per se, which only a few things meet, in most slander cases, the plaintiff has to show that he or she suffered actual harm. So they've got to be able to tie the untrue spoken statements to actual harm. So you've got to show that because of what you said, I lost a job, or you lost a customer. So an example would be if you worked for a prior employer and you list that employer on your application at your next job, and that employer, your former employer, says things that are untruthful about you and you don't get hired, that would be an example of which you may have a claim for slander. So let's say that the employer, your former employer, tells the prospective employer that you got fired for your job because you had embezzled money. If that's not true and the prospective employer doesn't hire you because of that statement, you may have a claim against the former employer for slander. Now, slander per se that we talked about briefly is where the statement is so bad that on its face it qualifies as slander. And that would mean you do not have to show actual harm. You don't have to actually show that you lost a job or a customer. So a couple of the examples, the book lists a few of slander per se, is a statement that a person committed a serious crime. So a statement that you, just the example we gave of you embezzled money, that may be enough to qualify as slander per se. Now, in the example we gave, I wasn't thinking about it being slander per se or analyzing as that. I was saying it as an example to show the actual harm that you suffer. So the statement could be something less than they embezzled money. It could just be that you were an employee that had problems showing up on time, you were rude to your coworkers, and you were insubordinate to management. And if those things aren't true, then that's not slander per se, but it would be something in which you could potentially have a slander claim against the former employer if you lost your job, your potential job with a prospective employer. So we talked momentarily about um, this before, but for non-public people, so private people like you and I, for us to recover, all we have to show is that the defendant acted with knowledge that we've got to show one of three things: either that the defendant acted with knowledge that the statement was false, or they acted in reckless disregard for facts, meaning that they didn't care to find out if the facts were true or not, or we got to show that the defendant was negligent in obtaining the true facts. They didn't try to find out. They didn't exercise proper care to find out and confirm whether the facts that they published were true or not. So we've got one of three ways that we can establish that they acted improperly. But if you do the negligence theory, the one in which they failed to take appropriate steps to find out whether the facts were true or not, then you've got to show actual damages. So that goes back to like what we were just talking about this a moment ago with slander. You're going to have to show that there is a loss of business or a loss of profit or a loss of a customer because of the untrue statements that were published. But now defamation for public figures, celebrities, public officials, like the president or, a famous actor like Brad Pitt, Angelina Jolie, Robert De Niro, the president, the vice president, governor, anybody like that is going to be a public figure, and they've got a higher burden because they have to show that the defendant acted with actual malice. So they can't show that they were negligent in obtaining the true facts. Rather, they've got to show that they acted with knowledge that the statement was false or with a reckless disregard as to whether it was false. So they either knew it was false or they disregarded it in seeking to find out whether it was false. So that burden of showing actual malice almost makes it to where it is impossible to prove these defamation claims against public figures. So you may have, you see things where the president or someone else may claim that they're going to sue for defamation. Well, as a public figure, they can make that claim and they can say those words, but them being able to say they're going to do that and them actually successfully recovering are two different things, and they're very difficult for a public figure to prevail on a defamation claim. As you would expect, a complete defense to a defamation claim is truth. If you can show that the fact that you claim was defamatory is true, then how can there be any damages? How can you have done anything wrong if what you published was only truthful? And so a complete defense to any defamation claim is proving that the alleged false statements are in fact truthful statements. Now the defendant is the one who always carries the burden to establish that the alleged false statements are in fact true statements. And if you establish the truthfulness of the statements, then you're going to have a complete defense to a defamation claim. The book also talks about absolute and qualified privilege. Those are possibilities, but they're very rare when they come up. But the book does talk about them, and they're good to know. The absolute privilege is going to apply to certain statements that are made by government officials, statements made in judicial proceedings, or statements made between spouses. The qualified privilege is mainly intended to protect statements that's made about one's own personal interests or business interests. Trespass to the land. This is like you would expect. Trespass is just invading, going on property, real property, without the property owner's consent. So I haven't asked someone to come on my property. They come walking on it, they walk across it, they don't do any harm to it or anything. But still, nonetheless, there's a technical trespass to the land. The intent is that to enter, not to be on the property without consent. So if you don't have to have an intent to not be on the property without my consent, all you have to do is have an intent to be on the property. So if you make a mistake and you're going to who you believe is your friend's property, but you actually go past his property and go to someone else's property, if they find you on it, you've technically committing the intentional tort of trespass of the land. The fact that you mistakenly believe that you're on your friend's property is not a defense, and in fact, it's actually completely irrelevant as to whether or not you completed a trespass. You can also have a trespass that occurs above or below the land. You can also have a trespass that occurs because you're once entitled to have, say, a piece of equipment on a piece of property, but once if you fail to move what was once allowed, if it's no longer being allowed and you fail to remove it, then you're committing a trespass on the land. So a trespass on the land is something that probably happens quite often, but people do not sue for them, especially because you have very limited damages that occur most of the time. If somebody just comes and improperly walks across your property or runs on it to pick up a baseball that got hit out of their yard into your yard. In those scenarios, any possible trespass of the land is minimal and you really have no damages. Although damages are not required, you're just not going to recover anything, so nobody's going to sue you for trespass to the land. Nuisance, this is a theory that comes up. Sometimes I see it more in the governmental context, but we'll talk about that in just a minute. So a nuisance is where you have a substantial and an unreasonable interference with the landowner's use and enjoyment of the property. So with the trespass, you're actually going on the property. In a nuisance, you're usually not on the property, but something's going on near the property that causes an interference with the landowner's use and enjoyment of their property. So a common example is if I'm having somebody that lives behind me in my property and I do a bunch of digging and I do my flower beds and it causes some changes and I put some dirt here and I move some other dirt somewhere else, there's a chance that I've rerouted or altered, I guess is the better word, the natural drainage flow for rainwater. So if I change it to where the rainwater flows differently across my land and actually results in an increase of water to the neighbor behind me, and it starts flooding his property, that's going to be a creation of a nuisance by me because um, I have done something that has caused perhaps a substantial and an unreasonable interference with the landowner's use and enjoyment of his land. If his backyard floods for 5 days after a medium to heavy rainfall, that's going to be a substantial and unreasonable interference with his use of the land, and I'm going to be the one that's responsible for it. I've not done anything to step foot on his property. Rather, it's the use of my property has caused a harm to his property. So another example, and these are given by the books, is when you have a noise or an odor. So if you are having parties at your house all the time and it's loud at midnight and it's waking up the neighbors, causing them to be unable to sleep, then you're going to have a potential nuisance violation. So odor, that happens if, say, you have a pig farm, and you have people living near you. Well, pigs kind of stink, and hogs, whatever you may have, and it could cause a odor or a stench is that you can smell at your home, and it makes it where you don't want to go out and use and enjoy your land. You don't want to go in the backyard because it smells so bad. In those scenarios, a nuisance is likely. Now, in looking at your use of the home, the courts will weigh the utility of creating the harm and the burden of preventing it against the nature and severity of the harm to the landowner. So they're going to look at the example of me altering my property, which in turn altered the natural drainage flow and caused the flooding in my neighbor's yard. They're going to analyze what I did, and the utility that I'm getting from the changes to my property, with also the cost that it's going to take me to change my land again to make the water flow such that it doesn't create a flood in my neighbor's yard. They're going to balance those against the harm, the flooding that my neighbor's suffering, as well as how serious and severe that flooding would be. If the flooding is slight, there's a better chance that I'm not going to be found to have a nuisance. That's got to be corrected. But if it is, the more substantial the flooding is, the more likely that a court would order me to alter my property to abate the flooding that was going on. So nuisances can be public or private, and we'll discuss those on the next slide. So a public nuisance is the unreasonable and substantial interference with public health, safety, peace, comfort, convenience, or use of land. And so the public nuisance is the ones where it's usually the governmental entity that's the one that's pursuing the nuisance action, and they're the ones that are taking the steps to have the nuisance abated. And so cities and counties do this quite often with, say, I know locally, probably 8 or 10 years ago, there was a farm in one of the surrounding counties here in Jackson, and someone had a pig farm, and it had bad odors, and the odors were being smelled by others in the town nearby and things like that. And that was an example of a public nuisance because it was affecting the peace and comfort and use of land of the public. A private nuisance is where there's an interference personal to the private landowner regarding his or her use and enjoyment of the land. So the example that I gave of me altering my property and flooding my neighbor behind my home, that would be a private nuisance because the private landowner, my neighbor, is the one who is having his use and enjoyment of the land impaired. Conversion, this is another intentional tort. It's one in which you're exerting such a degree of dominion and control over another's personal property that the person has essentially taken the property and converted it to his own use. So that's the fancy way of saying that you more or less stole some personal property from the person. And so in those instances where you've converted a piece of personal property essentially to your own, then the plaintiff seeks to recover the monetary value of the stolen or destroyed or the substantially altered property. Trespass to personal property. So just like you can have trespass to land, you can have trespass to personal property. This is similar to conversion, but not to the same degree of what conversion is. Conversion is where you actually take it. Trespass to the personal property is where you're just interfering with another's property, but you're not stealing it or taking it. And when we say property, we're not talking about land as in real property. We're talking about personal property, like using someone's car such that you are interfering with their right to use it, but you haven't stolen the car and taken it as if it's yours. So just like with the trespass to land, you doesn't require a wrongful motive. All you have to do is intend to exercise some degree of control over the personal property. So fraudulent misrepresentation, this is the intentional tort that will protect against the economic interests and the right to be treated fairly and honestly. So fraudulent misrepresentation is often referred to as just fraud or deceit. And so when I say fraud, I'm referring to fraudulent misrepresentation. But a fraud claim requires that the plaintiff prove that the defendant did one of two things: that he either intentionally misled the plaintiff by making a material misrepresentation of fact that the plaintiff relied upon, or the defendant must have failed to state a material fact when the defendant had a duty to speak because of a special relationship that he had with the plaintiff. So you've got to have one of those two, and the plaintiff has to suffer some damage as a result of the actions. So if the defendant failed to state a material fact when the defendant had a duty to speak because of their relationship, if they fail to do that, but there's no actual harm that occurs, then you're not going to have a fraud claim. But let's do an easy example is if you're buying a house or you're buying property, and the buyer goes to the seller, and the buyer says, have you had any flooding issues with this home or with this property? And the seller says, no, we haven't. Well, obviously the buyer is going to rely upon the representation that's given by the seller that there have not been any problems with flooding. That in fact is not the case, and the property floods, 3 or 4 times a year when there's a substantial rainfall, then the seller, who would be the defendant here, has intentionally misled the plaintiff by making a material misrepresentation, and the buyer is going to be relying upon that material misrepresentation. And when the house floods, then they're going to have damages. That is, the buyer is going to have damages because they're going to have to correct the flooding issue. And so they're going to have damages because of their reliance on the defendant's material misrepresentation. Now, another way that could happen is, for the second prong, is that when they're talking about it here, and the relationship between a seller and a buyer is probably one in which the scenario, the court would say you had a duty to speak on this fact. So if the buyer is talking about flooding and saying that he can't find any evidence of it flooding, and there may not be an intentional material misrepresentation by the seller, like we just talked about in our first example, but the seller may fail to state to the defendant that there is flooding issues. So this is the instance in which the seller remains silent. If the seller remains silent and doesn't speak out on the flooding issues they've had, they're going to be liable for a fraud claim under Part B. In a fraud claim, it's also important to remember that you've got to distinguish between what's an opinion and what's a fact. So a fraudulent misrepresentation, like we were just talking about in the scenario just a moment ago with selling the home, that's a statement of fact. He's stating a fact that the home doesn't flood, our property doesn't flood. That's different than an opinion. So you've to have the misrepresentation, it's got to go to a fact. There are a few instances in which an opinion may be enough to give rise to a fraud claim. And those three possibilities are where the defendant has represented themselves to the plaintiff as being specially qualified, basically being like an expert, and the plaintiff relies upon that superior knowledge. And so if you've got an expert giving an opinion and the plaintiff relies upon that opinion, that may be enough to rise to a fraudulent misrepresentation. An opinion would be enough if the opinion is from a fiduciary or a similar trusted person. Also, the opinion would be enough if the defendant stated its opinion as an existing fact or implying facts that justified a belief in the opinion's truthfulness. So if you present the opinion as fact, or you buttress the opinion with facts that justify the belief that the opinion is truthful, then you may be doing enough to convert that opinion to a claim of fraudulent misrepresentation. So in the fraudulent misrepresentation context, everyone has a duty to refrain from lying, because that's essentially what fraudulent misrepresentation is. In an arm's length transaction, that's one between people of equal means, no one party has a superior bargaining position over another. So these are two people buying or selling goods to one another, or performing services for one another. If it's an arm's length transaction to where there's no superior bargaining power, then there's no duty to disclose all facts that may be relevant to the party's decision. But in a fiduciary relationship is an example of a non-length arm transaction in which, in that scenario, the fiduciary must disclose all the relevant facts to the party. Malicious prosecution. These claims happen, but honestly, they're quite rare. The context in which they most often arise that I see in practice is for police officers. And we'll look at the elements in a second. I'll give you an example, but in these cases, the plaintiff must show that there was some prior proceeding in court that was maliciously instituted against him or her, and that it was a prior proceeding that was brought without probable cause, and that the prior proceeding terminated in the plaintiff's favor on the merits. So an example with a police officer is, and this is just a real life example, it was a case that I've defended. You have a police officer who goes to, someone is reported as potentially meeting a warrant that's out. So it's somebody who's wanted. They have a pending warrant. An off-duty police officer saw this person, reported it to on-duty officer. The on-duty officer showed up. The on-duty officer was there, and he was questioning that person with the warrant. Well, there was also another person there who had a gun, and the police took the gun from the third party, not the person who had the warrant for their arrest, but took it from the third party for safety. You just didn't trust the person, didn't know what they would do, and so they took the weapon, and when they took the weapon, they ran a background check. I don't know if the background check's the right word, but they ran a gun check to make sure that the gun was not stolen. Once they did that, they determined that there was a hit on the gun, and the gun was reported stolen from another state. So the police officer had the dispatch double check that number 2 other times, and all 3 times the number on the gun came back and was reported to the police officer as stolen. Now, mind you, the police officer does not see the report here, so he can't look at it to know whether the gun really is stolen or not, if it's the right serial number matches up. Well, in the instance, the dispatch made a mistake, and the serial number on the gun was actually one one number off from the dispatch report. So it was a very similar number that came up for the serial number, but they weren't exact. And so the gun that this third party had was not the gun that was actually reported stolen. The police officer did not know that. So the police officer arrested the third party, took her to jail, and she was booked and put in jail. Well, after she was put in jail and held there for a short time. It was discovered that the serial numbers were off, and so the charges that were brought against her were ultimately dismissed. She sued the police officer for malicious prosecution. That was an example in which you would see these type claims. Well, the malicious prosecution claim will fail in that case because although there was a prior proceeding, she doesn't have any basis to show that it was malicious because all he did was follow his job and he had a reasonable basis to believe that she had a stolen gun because he had a report from dispatch. And it was confirmed twice, so 3 times was told that this gun is stolen. So he had probable cause. Probable cause means that he had a reasonable basis for believing, in this instance, that she had stolen the gun. So he had a reasonable basis to believe that she had stolen the gun based on the report given to him by dispatch. And so this is an example of where there's no malicious prosecution because when what he did was justified based on the facts at the time that he knew them. At the time he knew them, there was no belief for him to know that the serial number was actually wrong and she had not stolen the gun. Now, if he had learned of the discrepancy between the two serial numbers and known that this was not valid claims against her based on the fact that the gun was not stolen, but yet he continued to push the case through and didn't agree to dismissal of it, that would be an example in which he would then be maliciously prosecuting the case. Interference with contractual relationships. We've talked about contracts last week, and this ties in to protect the legal right of people to enter into contracts. So we learned about contracts. Everybody has a legal right to enter into contracts, provided that you got capacity. It's for a legal purpose. You've got consideration. You've got a meeting of the minds. You can have a valid binding contract. And so this tort protects the parties' rights to enter into valid enforceable agreements. So essentially, what it does is it provides a remedy for when the defendant induces, that is, causes a party to the contract to breach the contract with the plaintiff. So in this scenario, let's take the example of you have two companies. One has agreed to sell some computer chips to another company, and they're going to sell them to them at a price of $50 a computer chip. And the company the buyer in this scenario is going to take them and use them in their computers that they produce and sell. So it's a contract that they've made, but if another chip provider comes along and they provide a better deal and know about this contract to sell the computer chips for $50, and they come in and offer to sell them for $40, and they encourage and ultimately cause the buyer to cancel the contract or void the contract or breach the contract with the plaintiff, with the seller, then they're going to be that third party that made the offer to sell computer chips for $40 is going to be subject to a potential interference with contractual relationships claim. So it's essential that that third party that offered the chips for sale for $40, that they knew of the contract, or that they had sufficient facts such that they would know that they should know that that contract to sell computer chips at $50 existed. So, and it's got to be encouraging. There's got to be some form of encouragement, some action done, some pushing, some involvement to induce, to cause the buyer to breach the contract with the seller. Because If they just provide an opportunity for them to buy chips from somewhere else, if they come and say, hey, you're buying them for 50, we can sell them to you for 40. We just want you to know that. We would love to do business with you, and that's all they do. They've only provided them an opportunity to buy from another place. And if they breach, then that's on them. You can't show that there was some interference by that third party defendant. So these claims to recover on these type claims, you've got to show that there's a valid contract between the buyer and seller. So here there was the valid contract of they agreed to buy, the buyer agreed to buy computer chips from the seller for $50, a computer chip. That was a valid contract. The third party knew about that contract, and they came in and offered it at $40. So they've offered it at $40, and they've done a lot of follow-up and emails and discussions and encouragement, and they've offered additional terms that are better. All of those actions are going to go together to help show that the defendant, the company that's offering the chips for $40, that they work to induce or encourage the buyer to breach that contract with the seller at $50 a computer chip. And there's going to be damages because the company that's selling computer chips for $50 is going to lose the sales that they would have otherwise had of selling their computer chips at $50. So in that example, there's an interference with contractual relationships. So there's also a tort called interference with business relationships. This is what the book refers to, an interference with prospective business advantage. Maybe other states call it that. Tennessee calls it an interference with business relationships. And I know some other states refer to it as that as well, but they're the same thing. So this tort covers instances in where there may not be a contract, but the defendant is nonetheless interfering with a business relationship. So it may not be that they're causing someone to breach a contract, but they're still interfering with your either current or prospective business relationships. So in these examples, the plaintiff must prove that the defendant interfered with a business relationship and that that interference caused damages. So if it is a relationship and it's somebody that you're close to closing a deal with, so let's go back to our example of the buyer is trying to work real hard and is about to close a deal with the seller in which they're going to agree to buy the computer chips for $50. There's no contract yet, but they're really close. Well, if the other company comes in and they are able to cause them to not sign that contract at $50 and they get them to sign it at $40 with them, they may be able to argue and show that that third party defendant the party selling the chips for $40, that they interfered with the prospective business relationship there, and that interference caused them damages by losing the sales contract. So in that example, they may be able to pursue a claim of interference with business relationships. Now, the problem that becomes hard about these cases is that it's got to really be something more than just natural competition in the market. So just competing fairly, or even just being a good, aggressive company or marketer is not going to be a tort of interference with business relationships. So, if you offer them a great deal on a price, that's probably not going to be enough to rise to the level of an interference with business relationship claim. For that reason, that's why it becomes difficult to prove and succeed in these claims.